Hale. Allow me, therefore, to introduce very briefly, if that's okay, Baroness Hale.
You don't have to do it at all if you don't want to.
Allow me to introduce the Right Honourable Baroness Hale of Richmond, member of the House of Lords and former Justice and President of the UK Supreme Court, who will speak under the title of UK Resilience Under Threat, ? Over to you, and thank you so much.
Thank you very much, Ed. It's lovely to be here, and I'm looking forward to learning from everybody else who speaks. I know that Robert Spano and Tim Eicke are going to discuss the current situation in relation to the European Convention and Court of Human Rights, not only in this country, but elsewhere in Europe too. So I don't want to say much about that, other than to repeat my amazement that total withdrawal from the convention is seen by two political parties in this country as the solution to the particular challenges of mass migration, when there are plenty of other ways of tackling the problem, and the convention has done so much that is good for the people of this country. And that's the message we've got to try and get across, as Naomi has just been telling us. But I'm not going to do that. I'll leave it to you.
I'm going to leave it to you. Oh, yeah, right.
Okay. But I see that particular issue as part of a much wider problem. So I want to discuss the resilience of the UK Constitution in the face of current threats. It's widely accepted that liberal democracy is in crisis in much of the world as a result of the growth of illiberal democracies. And this is not only in expected places like parts of Latin America, but also in unexpected places like some of the member states of the European Union and one part of North America. We've seen the appropriation of the trappings of liberalism in order to undermine it, as when freedom of speech is used to peddle alternative facts. We've seen the growth of populism, gaining the public support by telling them what they want to hear in a way which appeals to their emotions, rather than telling them the truth about the problems we face and what can and cannot be done about them. And we're not immune to the perils of populism in this country. So what are the threats? Well, first, there are the media. Reference has already been made to the media. And Tim has an excellent story about it, which you may or may not mention. Anyway, but few can forget the infamous Enemies of the People headline in the Daily Mail, after the Lord Chief Justice, the Master of the Rolls, and a senior Lord Justice of Appeal, no less, had ruled that the Prime Minister needed the authority of Parliament to give notice of our withdrawal from the European Union. But it's not just the media. Few can also forget the failure of the then Lord Chancellor, who had recently sworn an oath to uphold the rule of law and the independence of the judiciary, to defend the judges from this outrageous and unjustified attack. As the Attorney General has recently been saying, unjustified attacks on the motives of judges are also an attack on the rule of law. If you undermine people's trust in the judiciary, you risk undermining the ordinary instinct of most people to obey the law and meet their responsibilities. Okay, can you hear me? I'm sure you can hear me without this.
But not the people online.
No, that's the problem, isn't it? But the point is, if you're not going to get a fair hearing, why bother to obey the law and meet your responsibilities? And there was another egregious press example recently when Lord Justice Bean was accused of bias because of his previous links with the Fabian Society, the Labour Party, and the Society of Labour Lawyers, when he, along of course with two others, set aside the interim injunction preventing the Bell Hotel in Epping being used to house asylum seekers. I can't immediately think of an example of a judge with known links to the Conservative Party being similarly accused of bias. If anybody can, please let me know, because it'll be a nice footnote, won't it? Yep. But it would, of course, be equally dangerous. Tabloid newspapers are one thing, but senior politicians ought to know better. As Shabana Mahmood, when she was Lord Chancellor, said when giving evidence to the House of Lords Constitution Committee on the 3rd of September. She was referring to the shadow Lord Chancellor, Robert Jenrick, and the shadow Home Secretary, Chris Philp.
It is, as she said, one thing to criticise judicial decisions, but another thing entirely to call in question the motives of the judges. Undermining confidence in the judiciary undermines the rule of law, she said. But since then, the threats have become more explicit. The Shadow Justice Secretary has proposed abolishing the Judicial Appointments Commission and reverting to the old system, where judicial appointments were largely in the hands of the Lord Chancellor. But think about that. In those days, the Lord Chancellor was a senior lawyer at the end of his political career, who was also head of the judiciary of England and Wales and swore the judicial oath. Not a career politician, not necessarily a lawyer, with serious ambitions, but no such instinctive commitment to the rule of law and the independence of the judiciary. So to revert to the previous system would, in my view, be extremely dangerous. We currently have a system which guarantees that judicial appointments are not made for political reasons, and long may it remain so. He also seems to want the power to dismiss so-called activist judges. Now, an activist judge is a judge who makes decisions the politician doesn't like. It's as simple as that, in whichever direction you go. And that, of course, calls in question the independence of the judiciary, which has been enshrined in our Constitution since the Act of Settlement of 1701. I cannot tell you how frightened I am that senior members of the opposition could put forward such shattering proposals for our constitutional arrangements. And so I keep on saying so. Of course, some things are not new. In June 2022, an all-party parliamentary group on democracy and the Constitution published the results of their inquiry into the impact of the actions and rhetoric of the executive since 2016 on the constitutional role of the judiciary. They quoted Lord MacDonald, QC as he then was, a former director of public prosecutions, who said that a vogue for ministerial attacks on judicial decisions began in the late 1990s and early 2000s. This seemed to be part of New Labour's attempt to present itself as tough on crime, but it had paved the way for more egregious ministerial attitudes since. The group were particularly worried that some of these attacks had come from the members of the government charged with upholding the rule of law, that is, the Attorney General and the Lord Chancellor. They quoted Sir Jonathan Jones, former head of the government legal service. Historically, the law ministers have kept out of public debates, save for when it became necessary publicly to defend judges. Now they are leading the criticism. Actually, I think it was one in particular that was doing it. Let's not quarrel. But the group also discussed something which was much more troubling. In 2021, the then Lord Chancellor, Robert Buckland QC, in an article for the Daily Telegraph, commented that he believed that the judges had become more restrained since the backlash over the decision in the prorogation case. And in a speech to Right of Centre think tank Policy Exchanged, he claimed that the judges were exercising more restraint after being encouraged to do so by the executive. Well, if that were true, that would be equally troubling, would it not? Now, the all-party group didn't express a view about whether political criticism of the judges had led to a change in the judicial approach to public law cases, but they did point out the undeniable truth that public law challenges, and in particular human rights challenges to government action, had become markedly less successful in the Supreme Court since the beginning of 2020. Now, I myself think, as I must, that this was not a reaction to the government's threats, but the result of changes in the composition of the court. And you can all work out what I mean by that, if you want to. Yeah. But previous government ministers have done more than criticise the judges. They have on occasions refused to obey court orders. Indeed, Dominic Raab suggested legislating to give ministers the power to disregard judicial decisions with which they disagreed. And of course, from time to time, they've done their best to rein in the scope and availability of judicial review and human rights claims. So, this is a very gloomy picture, and it's not one that's improving. So how can we maintain constitutional resilience in the face of such pressures? Now, there's going to be lots more about this afternoon. So I want to go off-piste, if you and take a look at Sri Lanka, which I have recently visited. And it's a fascinating place. And I want to use it as a case study. Professor Dinesha Samararatne, yes, that's right, of the Universities of Columbia and Melbourne. Colombo. Now, she defines constitutional resilience as the ability of a constitutional democracy to absorb deliberate attempts at undermining its fundamental values, while retaining the same basic structures and ways of functioning, the capacity to limit the actions of those deriving power from it, and the capacity to adapt, to respond to, and deal with such deliberate attempts. Now, Sri Lanka became an independent dominion within the British Empire in 1948. Like the other dominions, it was presented with a Westminster model constitution. When it became a republic in 1972, it adopted a new constitution, but still on the Westminster model. This was amended in 1977 to introduce an executive presidency along the lines of the French. And this was carried forward into the new constitution adopted in 1978. Now, an executive presidency does not sit well with a Westminster model, but promises to abolish it have so far not been met. Every new government has come in with promises to abolish it, and somehow they never have done, because it's incredibly convenient. So after 1978, Sri Lanka went through turbulent times. The majority Sinhala population dominated government and made its own language the official language and its own religion the official religion. And this led to protests by the Tamil community, which developed into 2.5 decades of civil war, ending in 2009 when the government defeated the Tamil Tigers and slaughtered large numbers of the civilian Tamil population. The following year, an amendment to the constitution removed the 2-term limit on the executive presidency, and in effect gave the president power to make appointments to high offices, including the senior judiciary and to independent commissions. There was little opposition to this authoritarian measure, and a challenge before the Supreme Court failed. Intriguingly, I find this delightful. The court held that allowing the president to stand again gave the voters a wider choice, thus affirming the sovereignty of the people. Do you like that? Yeah. Despite this, the Chief Justice who had written that judgment, Kirani Bandaranayake, was herself impeached in 2012, following a ruling which the government didn't like. A parliamentary select committee found 4 charges of misconduct against her proved. She claimed that the proceedings were contrary to the rules of natural justice. The Supreme Court ruled that the procedure for impeaching judges had to be provided by law and not by a standing order of Parliament, as the Select Committee procedure had been. So they quashed the report of the Parliamentary Select Committee. But the government ignored this and proceeded successfully with the impeachment. A new Chief Justice was appointed in her place. Then came elections in 2015. And of course, the President, Mahinda Rajapaksa, stood for a 3rd time, but he lost the election. Soon after, the newly appointed Prime Minister wrote to Chief Justice Bandaranayake saying that there was no impediment to her continuing to hold office, and also wrote to her purported successor saying that his appointment was null and void. So Chief Justice Bandaranayake resumed office, but retired the next day. So that's one constitutional crisis in Sri Lanka. Another constitutional crisis came, there were many more. I'm just taking these 2 examples, came in 2018, when the president purported to remove the prime minister and appoint Mahinda Rajapaksa, the former president, and a member of the opposition in his place. I said it didn't fit well with the Westminster model of constitution. But Rajapaksa could not command a majority in Parliament. So the president first prorogued and then dissolved Parliament. But the Supreme Court issued an interim order suspending the dissolution and followed this with a ruling that it was null and void. Oh, that's an exciting idea in this country, isn't it? Yeah. But they have a written constitution, so of course it's possible. Yeah. Meanwhile, the Court of Appeal issued an interim order restraining Rajapaksa from acting as Prime Minister. And after the Supreme Court's decision, he stepped down and his predecessor took over once more. So in other words, that one was successfully resolved in favour of the Constitution. Now, Professor Samaratney points out that the impeachment of the Chief Justice in 2012 to 13 is an example of constitutional vulnerability, while the resolution of the crisis in 2018 was an example of constitutional resilience. So what was the difference? She argues that the efforts of the legal complex, that is lawyers, judges, academic lawyers, are not enough. The legal community was very active in opposing the impeachment of the Chief Justice in 2012 to 13, as indeed was the international legal community, including the Human Rights Committee of the Bar of England and Wales, but all to no avail. She also says that the impeachment had a debilitating effect on the Supreme Court and its jurisprudence on fundamental rights in the aftermath was weak. Well, that's troubling in itself. But compare this with the court's response to the constitutional crisis in 2018. Declared that the president's decision to dissolve parliament was a violation of the right to equality and therefore null and void. The legal community was also very active during the constitutional crisis of 2018, although lawyers were understandably divided on the interpretation of the Constitution, and so the Bar Council couldn't issue official statements as it had during the impeachment crisis. But she argues that it was the combination of the legal complex with public guardians, especially the Speaker of Parliament, and the mobilisation of the citizenry which succeeded in defending the Constitution in 2018. During the impeachment process, the then Speaker could have acted to ensure that it was conducted properly and in accordance with the rules of natural justice, but didn't do so. By contrast, in 2018, the Speaker stood up for the rights and privileges of the majority of the members of Parliament, reconvened Parliament after the Supreme Court's interim order, and presided over the passing of a no-confidence motion against the purported Prime Minister, despite the challenging circumstances. The challenging circumstances included some MPs preventing the Speaker from taking his chair, throwing a chair at the police officers protecting the Speaker, and throwing water mixed with chili powder at the police officers. No. Challenging times in that country. Yeah. But also during the crisis, she points out, citizens actively mobilised around political issues and demanded adherence to principles of constitutionalism and democratic governance. There were protests, including an almost daily protest in late afternoon at a prominent roundabout in Colombo. People took an interest in the Constitution and debated its interpretation. So she concludes that this spontaneous coming together of citizens on a specific political and constitutional issue of high significance shaped public perceptions and strengthened the already mobilised actors within the legal complex and other public institutions. It was the synergy between them which led to the constitutional resolution of the constitutional crisis of October 2018. So how would we do in this country? Well, I think we're going to have to talk about that for some more. I mean, on the whole, the legal community does stand firm in defence of the rule of law and the independence of the judiciary, on the whole. And the key players in Parliament, the Speakers of the House of Commons and the Lord Speaker, presided over the reconvening of Parliament in the wake of the Supreme Court's decision that Parliament had not been prorogued. But where the public stood in that constitutional crisis is more difficult to determine. They certainly hadn't campaigned in the way that the Sri Lankan public had campaigned. The legacy media took our decision comparatively calmly, but I don't think that social media did so, and neither did the government and many politicians. Dire threats were made to abolish the Supreme Court or to politicise the appointment of justices in future. It would not be surprising if my successor had felt under existential threat for a while. And not only that, the rule of law is also threatened if the justice system is starved of resources. And we know that that's been going on for decades, but particularly after 2010. So, and the legal complex has not been able to do anything about that. But is the public on our side? We must all be worried by the media and politicians who stir up a public mood which doesn't understand or respect the rule of law and the independence of the judiciary. Will we be able to rely on the synergy of the legal complex, official guardians, and the general public to keep our constitution, such as it is, safe? I fear that the efforts of the legal complex will not be enough, and public opinion appears to be being turned against us. So how can we persuade the general public that these things matter to them? Perhaps, as Chris McCrudden has suggested, we should take a leaf out of the populist book and start appealing to everybody's emotions. So, that's just to frighten you all. I hope you'll leave today feeling a little less frightened.
Thank you. Thank you so much, Baroness Hale, for those insights from Sri Lanka especially, and the note on which you end, which stirs us into action and makes me think of the complacency potentially that there is in this country about constitutional fundamentals in a populist environment. Our next speaker, if I may, I should have added, sorry, online you would be able to find detailed biographies of all our speakers. But I turn now, if I may, to Robert Spano, who is a partner at Gibson, Dunn, and of course a former judge and president of the European Court of Human Rights from when he was a judge from 2013 onwards. His topic is the European Court of Human Rights process-based review, partnering with national authorities within a multi-layered system of fundamental rights protections. I hand over to you.
Thank you very much indeed, Ed. That title should have been maybe a bit shorter. It's not as complex as it seems. I want to go on a bit of an historical journey with you because I think history is an important touchstone for parts of our debate today. History tends to repeat itself within the human construct. And I think the kinds of conflicts and challenges we are facing are not novel in a historical, if you look at contemporary historical history of at least Europe and the Western Hemisphere. And I think that is an important part of the puzzle. So I want to proceed in three parts. I want to begin by giving you a bit of a historical snapshot of the trajectory of the European Court of Human Rights, parts of which are not necessarily well known, but they are important to understand the situation we are in now and the move towards a true multi-layered system of human rights protection under the convention system. And I know Tim will then complement with issues related to the dialogue between judges, both at international level and national. So I'll start with a bit of history, and then in my second part, talk about the substance of my intervention, which is the move to what I have called and others have called process-based review. Talk a bit about its essentials, but also its pros and cons. Confront some criticism that has been leveled at the court's jurisprudential and methodological moves in that regard. And then in my final part, say a few words about the future, which unfortunately may echo large parts of what Lady Hale's just said, but I want to do it from the perspective of the convention. So if we begin at the beginning, we are celebrating the 75th anniversary of the European Convention on Human Rights, which was adopted in Rome on 4 November 1950. But it's important to bear in mind, and I'm not sure that everyone in the room knows this, the European Court of Human Rights is younger. The European Court of Human Rights was established by the decision of the Consultative Assembly of the Council of Europe in January 1959. So the court is 9 years younger than the actual convention itself. And when the court started its journey in 1959, the expectations, and if you want to read about this in the most comprehensive manner, you read Ed Bates's book on the evolution of the convention, which I always say is the best text that I've read on this. But if you look at the first part of the court's history, which I've usually talked about 1959 to approximately 1973-74, the court was internationally a non-issue. It was an institution that many politicians viewed as post-Second World War tokenism. It was meant to symbolize aspirations in relation to or as a reaction to the atrocities of the Second World War. but it was not conceived and it was not expected to become a real player in national politics. Far from it. And I think it's safe to say that if the politicians of the 1950s would have been told that the court and the convention would operate as it does today, they would not have believed or expected that to happen. From 1959 to approximately the middle of the 1970s, the court, as I said, was an institution within a system where a filtering system called the European Commission on Human Rights really made the court a tool not often used in international disputes. So rare were the court's pronouncements that in 1964, the first Danish judge of the European Court of Human Rights, Professor Alf Ross, who had been a statesman, a legal philosopher. He is indeed in the Nordic countries where I hail from. He's one of our greatest legal philosophers in methodology and the sources of law. It was his dream to become an international judge, which he did in 1959. But in 1964, he wrote an article called The Unemployed Court, where he lamented the fact that he was a judge on a court that had nothing to do. How things have changed. In the 1970s, the court started to become the court that it is today. The first phase, I think Ed calls it the diplomatic phase. The second phase, from about the 1970s up until what I term to be the Berlin Wall, the fall of the Berlin Wall in 1989, is called the judicial phase. The reason is that then the court became what it is today, more or less. Basically, all of the constitutional principles of the convention and the methodological principles were laid and set in UK cases in the 1970s. Tyrer versus the United Kingdom, Golder versus the United Kingdom, Handyside versus the United Kingdom, which expressed the principle of subsidiarity, the living instrument doctrine, so forth and so on. Now you can ask, why was this possible? Why was it possible for an international court to decide cases against one of the founding states, the United Kingdom, bastion of liberal democracy, without massive political pushback? There was pushback, to be honest, but it was such that it was accepted. And why was it accepted to the extent that we see the court being able to progress as it did? That is because a court like the European Court of Human Rights, and like any international institution, does not operate in a vacuum. The 70s and 80s into the 90s was the apogee of international multilateralism, the integration of international politics and national politics, the integrationist developments within the European Union. For those of those that know European Union law, all of the seminal judgments were laid by the European Court of Justice, the Court of Justice of the European Communities then, in relation to direct effect, the supremacy of EU law. That all happened at the same time. Why? Again, because there was an appreciation of political acceptance to the moves being made by international judges. And this is an important part of the overall picture we're seeing. International justice never operates in a vacuum. The third phase, the expansion to the east, occurred with the fall of the Berlin Wall, where the Council of Europe expanded exponentially up towards, at its maximum, 47 states by the fall of the Berlin Wall and the independence of the communist states. Now that, of course, had a massive reaction or a consequence for the convention system. Because then you had states which were not at all in a situation to uphold the minimum safeguards of the convention enter the convention system, and you had a young generation of lawyers in these states who aggressively pushed for democratic and constitutional change in their countries, relying on the convention as the baseline. What happens there is, and into the new millennia, the case law of the court started to rise massively into the tens of thousands, and in 2011 to 160,000 pending cases. At the same time, we see political backlash starting slowly, but progressively in the first decade of the 2000s. The Western Hemisphere, the Western European states, that were, of course, a part of this process because the court had to deal with Eastern European cases, coming to conclusions which the Western European states often had difficulty accepting. And that started to create a question of the internal balance between the inside the convention states and the integrity of the case law. And there were legitimate arguments that why do we need an international court where we have a fantastic constitutional system of our own, and we have great judges in our own country that know the convention inside and out, and not least in this country, after the adoption of the Human Rights Act, the questions arose, why should we be subject to a court that is basically dealing with human rights questions in countries that are far inferior to ours? Now, this culminated in what I consider to be a new phase, which started about 2012. And I think the Brighton Declaration of the UK presidency in 2012 was a turning point. And I think that's going to be for my last part. It's an interesting part, a historical example of potentialities for the future of the convention system today. And I will explain that in a moment. The Brighton Declaration introduced Protocol 15, that process, and really an explicit enforcement of underlying principles that were already embedded in the case law, but that were given a push at the international political level, in particular the principle of subsidiarity and the margin of appreciation. As many of you may know, I call this the age of subsidiarity. That's where it started. And I think I can safely say, and I'm pretty sure, well, I'm not going to speak for him, that Tim agrees with me on this, that in the last 10 to 15 years, there has been development in the case law in that direction. And that brings me to my second part. What is that development? There are many words used to describe it in the literature, the procedural term, process-based review. But let me begin with a threshold question. There is nothing novel to the principle of subsidiarity. It has constituted the genetical foundation of the system since its inception. The system was always conceived as a multi-layered system, with the court being a safety valve, but human rights protections, both the prevention of human rights violations and the protection of individuals, was in the hands of the states. If you read Article 1 of the Convention, it is directed at state action and inaction. The idea was never that Strasbourg would be the destination point for pan-European human rights protection. Both that is factually impossible, empirically something that can never be operationalized. But the reason that the court had to take the reins in the 70s and 80s is because the language of human rights was not recognizable to national authorities. So it had to pave the way, create the underlying foundational system for the national authorities to do their jobs. And I think when we were in about the 2010s, the time had come to really put that into place, to make it clear that it was in the best interest of the national authorities to take their jobs seriously, to create an actual system of shared responsibility, because then the court would understand that its job had been done, and it would only intervene in exceptional cases. And it also made clear that, at least when it comes to the qualified rights, Articles 8 to 11, and the fact that the court has interpreted the necessity principles in the paragraph 2s of these articles based on a balancing principle called the principle of proportionality, it means that in effect, the actual substantive outcomes will be a balancing exercise. And so the court started more clearly saying to the national authorities, please demonstrate to us that you have actually done the balancing. If you have done it, and you have done it in a manner where you've integrated the criteria broadly construed from the court's case law, we may disagree that if we would have sat on the UK Supreme Court or the Supreme Court of Norway or wherever, we may have come to a different conclusion, but human rights law is not mathematics. It's not 2 + 2 is 4. So the process-based review development is actually putting into place a true multi-layered system of human rights protections and bringing the convention back to its genesis as a system of human rights protection, which happens as close as possible to the human person at national level. So it's nothing novel, and I think it has been very successful in many countries. And nowhere has it been as successful as in the United Kingdom. The United Kingdom's legal community's embedding of the convention is, I think, what the founders envisaged as being the optimal state of affairs. So the fact that we're actually having this conversation in this country is, for me, frankly, mind-boggling. It makes no sense in any shape or form. And it demonstrates that we're not dealing with questions of law. We're not dealing with questions of legal methodology. We're not even dealing with questions of, Robert Spano from Iceland, why should he be deciding cases, which has an impact on UK citizens? It's a far more deep and more difficult beast that we're dealing with. So while I'm always wanting to be optimistic, I'm afraid us talking to each other in this room is not going to solve the issue. And myself, Lady Hale, Tim Eicke, Ed Bates, and others can cry foul as often as we want in legal conferences. That is not going to move the needle. That's as simple as that. Because the system, when it comes to the way it should operate, actually operates. Nothing is perfect, but it actually operates now as it should. The reason there are so few violations in the Strasbourg Court is because that, broadly speaking, the United Kingdom at present, what happens in the future, I don't know. But at present, human rights protections in this country are at a very high level. That's as simple. No country protects human rights perfectly, and there may be disputes, but there are very few countries in the world, potentially with some others that I can mention, where human rights protections are at the level they are as in the United Kingdom. And we should celebrate that. And it's important to bear in mind, and that brings me to my final part, what the future could look like. When I'm confronted with questions about why should we remain in the convention? After all, we have fabulous courts in this country. If you look at the way in which the opponents of the convention speak, at least within the legal community, they refer to the fact that there is no need for a European Court of Human Rights because we have national courts that do the job. Now, I would argue there is probably no country in Europe that is as vulnerable to massive illiberal tendencies and potential constitutional backlash like the United Kingdom. You do not have a written constitution. The courts cannot annul legislation from Parliament. So if what happens in this country is what has happened in some other countries, and I know UK lawyers find it fanciful that the national UK courts would be victims of state capture, But look at what is happening in a country which Brenda didn't mention at the outset, but is in another part of the world, which is considered to be the bastion of judicial independence. We will see how the colleagues in Washington will deal with this moving forward. But the idea that UK judges are going to be immune to political traditions and tendencies in this country is not belied by history. So the United Kingdom is very much at the forefront of a potential threat that, if leaving the convention basically allows Parliament in its omnipotence and being omnipresent in your constitutional system to be capable of completely disregarding all of the civil rights, civil and political rights, which are protected by the convention. And it will be for Parliament to legislate. And I'm afraid Lady Hale has often said this, it's Parliament that decides, ultimately. I have never heard any UK judge give the impression that there is a constitutional rule that would allow the UK Supreme Court to decide that an act of Parliament, which clearly violates human rights laws in a post-convention world, could be overruled by the courts. That's just not the way the UK constitutional system works. So what you're left with is, you're left with a possible system of political majorities with the kind, speaking the kind of language we see today in this country, where actually you do not have what many other European states have, at least the possibilities of national courts and judges striking down the most extreme and exaggerated measures by the legislature. You do not have that protection. So in some sense, the UK is the country with the least, which should be as far away from withdrawing from the convention as any possible country in the Western Hemisphere under the European Convention. What we need to explain to the public is explain with human stories about how this could look like. Bring stories to the people about what happens in democracies which decay and where you do not have independent authorities like judges that can protect you. In principle, judges in Germany in 1933, under the Wehrmacht Constitution, were independent. What happened? Fervor, political trajectories, human nature, fear, emotions, populism infiltrate. And ultimately, we're all humans. That is why we enacted the European Convention on Human Rights. It was meant to be an external check for exactly the kinds of developments we are seeing today. So legal technicalities will not fix things. Rising up and talking about judicial independence will not fix things. It's human stories. It is stories about what are the kinds of issues, kinds of matters, what is the reality you can be confronted with in the future if you decide to take that step. And I'm afraid I don't see enough of that. And certainly it cannot come from people like me. It has to come from influencers, politicians, young people on TikTok, people that actually move the needle. Sorry, we just don't. It's as simple as that, unfortunately. So that is a campaign of public outreach based on human stories. That is the only way you're going to move the needle in this country. But you need courageous politicians to take that step. You need to have good communicators to take that step. And you need to prepare for a debate which is not based on technicalities. You cannot confront the farages of this world with technicalities. That's just not going to move the needle. It has to be based on similar, although reasonable, aggressive language, which uses language that people understand. And the realities most people, at least today, will not want to live with. Thank you very much.
Thank you very much indeed. The challenge in which you end your presentation there is very much in tune with that of Lady Hale at the end of hers. And it's a challenge that occurs to me is a very great one, as you identify, especially in the face of populist messages in the tabloid media, for example. We have Professor Alice Donald here, who may be able to say a word or two about that in Q&A, and I'm also conscious we have many others in the room, such as Stuart Wallace and Maris Amos, who've written recently about the vulnerability of the Human Rights Act and the constitutional issues relating to reform of the Human Rights Act and the British Bill of Rights proposed. And one last thought, and this will lead me into introducing our next speaker, is the discussion that you introduced us to there in relation to subsidiarity, and of course, which underlines the importance of the Human Rights Act, so that national judges may provide their own perspective on the meaning of convention rights, and which therefore facilitates a dialogue with the Strasbourg Court potentially on these matters. And that may perhaps lead me into our next speaker, who is Judge Tim Eicke, KC, judge of the former judge and just of the European Court of Human Rights. No longer.
Or retired judge is my badge.
Now back practicing at Essex Court Chambers. You are to speak, and we look forward to this. Thank you so much. On the subject of dialogue as part of multi-layered system for the protection of human rights.
Thank you very much, Ed, and thank you very much for having me. And it's a privilege to be on this panel. I'm not sure. Well, in one sense, I'm not sure I can cheer you up after these two first introductions, both from a domestic and a Strasbourg point. And to some extent, perhaps also, I feel I've only been back 6 weeks, that I'm still kind of one foot in the judicial camp and therefore feel slightly more constrained in what I can say. But one of the things I wanted to look at, especially in terms of the multi-layered aspect, and probably pick up one aspect of what Robert said about how well embedded the system here is, and collaboration between the courts, how that truly makes that multi-layered system work. And I think that is a success story. It's a positive story, and I think it is a story also where, while not answering the challenge in a sense posed by Lady Hale about how is the system going to stand up, to me it is that we are in a place in that dialogue which actually means that at least we're at one, the judges here and the judges in Strasbourg, and we talk to each other, we collaborate. And the question really is, how can courts respond to the threat with all the limits that come with not being able to respond publicly and doing that kind of work. We see some of the enhanced outreach work that's being done. So I wanted to look at dialogue, because I think that is a particularly success story in a way. And I want to start, and this is not a chronological start, but with noting, and Robert gave us the historical tour, that as recently as 2018, the member states in their Copenhagen Declaration, of course, encouraged and demanded enhanced dialogue between the national authorities, the national courts, and the European Court of Human Rights, in order to make the system of shared responsibility effective. That was a recognition, in a sense, of something that had happened and been going on for a long time. I mean, I'd been at the court 18 months when that happened, but I think within 6 months of my arrival, in fact, I saw with Robert and Lady Hale, we had a dialogue meeting in Edinburgh, where we had a very constructive engagement. And of course, Dean Spielman, when he was the president in 2015, dedicated his Sir Thomas More lecture at Lincoln's Inn to the topic of judicial dialogue, and noted that judicial dialogue is intrinsic to the very nature of the convention system, and intrinsic to the overriding concern that the protection of human rights be effective. Now, what I wanted to do is just reflect, as I said, I'm only just on some of my experiences over the last 9 years, quite a few of which I've shared with both my co-panelists, that the dialogue played out in relation to the UK and how it at times very definitely and clearly advanced the interests of justice and enhanced cooperation in the multi-layered convention system. Now, in focusing on the UK, of course, I don't want to suggest that a similar dialogue does not also take place with other member states. And in fact, I've had the privilege throughout my time at the court to be a member of the court's delegation to the ECHR, which is the meeting and the dialogue every 2 years with the highest court of the 4 German-speaking jurisdictions, Germany, Austria, Switzerland, Liechtenstein, and the CJEU. But the reason I want to focus on the UK, apart from being in London and the current debate, is that, of course, I have been most closely involved with that dialogue with the UK. And then it's been mentioned, and I'm glad it's been mentioned a couple of times, speaking in London shortly after the 25th birthday of the Human Rights Act, I cannot help but note that the form of incorporation of the Convention in domestic law has in fact enabled a particular deep and rich dialogue between the UK jurisdictions and the Strasbourg Court. Having incorporated the Convention into Schedule 1 as it is, the very text of the Convention, and therefore enabling the UK courts to speak the same language as the Strasbourg Court, rather than adjudicating on fundamental rights through their own constitutional catalogues of fundamental rights, as we would see it in Germany or Ireland or other jurisdictions, has meant that much of the UK's human rights jurisprudence is widely read, widely understood, and its detail and care greatly appreciated within the Strasbourg Court. Now, dialogue in the literature has frequently been subdivided into dialogue through judgments and informal dialogue, not a dichotomy I'm particularly comfortable with, and not one that I think really does justice to the richness and the nuance and variety in the judicial dialogue that takes place. But looking at the terms of dialogue through judgments, this of course happens primarily, but not exclusively, through judgments against the UK, in which the Strasbourg Court is seen as having misunderstood important aspects of domestic laws. And you all know the Horncastle-Al-Khawaja dialogue, in which both Lord Phillips for the Supreme Court and Seneca Spratt in a separate opinion expressly talked about engaging in a dialogue in order to get the law right, and the Vintner and others and McLaughlin dialogue in relation to Article 3 and whole life orders. But of course, that is ongoing. Those are the highlights. But even if one looks much closer, reflecting for today, there are more recent examples of such dialogue. I, for example, would mention the case of Sanchez in April 22, on which both Robert and I sat, concerning extradition to the US to face, if convicted, a life sentence without parole. In that judgment, the Strasbourg Court engaged with a long line of decisions by the High Court in this country, in cases such as Harkins and Hafiz and others, where they decided that they would not consider themselves bound to follow the court's chamber decision in Trabelsi. The Grand Chamber, when it came to it in Sanchez, in its judgment, took the opportunity to make clear that the Winter criteria did not in fact apply in their full force in extradition as compared to domestic context, and rather unusually in my experience, expressly held that Trabelsi should be overruled in the context of the extradition context. And then the second example I would probably give is the much more recent judgment of Hora against the UK, adopted on the 2nd of September 2025. It was one of the last cases I sat on and published on the 23rd of September concerning prisoner voting. In that judgment, the court in fact engaged in a three-way dialogue. One, it engaged with and had regard to the very detailed debates in the UK Parliament following the judgments of Hurst and Greens and MT. Secondly, it engaged with and gave due weight to the 2018 decision of the Committee of Ministers, closing its examination of the Hurst group of cases. And thirdly, and in terms of judicial dialogue, most importantly, engaged with and ultimately adopted the approach advocated by the UK Supreme Court, in particular Lady Hale's judgment in the 2013 Chester judgment. So that's good examples of an ongoing dialogue where I think both courts are engaging with each other, and the Strasbourg Court is responsive to the points made to it by our judicial colleagues domestically. I also want to mention one other different and more direct dialogue through judgments, which is one that has left a deep impression on me, and that is the dialogue that took place in the case of Charlie Gard. Charlie Gard, as you will recall, concerned the withdrawal of life-sustaining treatment from a terminally ill child, which, being private law proceedings, had come to the Supreme Court, who refused permission in June 2017, as a result of which the the parents, in their own name and in the name of the child, came to Strasbourg and applied for and were granted a Rule 39 indication. That, as I understand it, was the first time the government had wind of those proceedings and then applied to the Supreme Court for an order to stay the result of the domestic litigation in order to enable the Strasbourg court, under its Rule 39 mechanism, to consider the case more fully. And as a result, in a judgment, I think some 11 days later, the UK Supreme Court not only granted that further stay to enable the Strasbourg court to consider the application fully as a chamber formation, but in what for me is one of the, if not the best example of the multi-layered system at work, included 2 paragraphs in its short 22-paragraph judgment directly addressed to the court, in which it, and I quote, respectfully urged our colleagues in the ECHR to do everything in their power to address the proposed application by 10/11 July 2017. We consider, the court said, at present that we would feel the gravest difficulty if asked to act yet further against Charlie's best interest by directing an even longer extension of the stay, end quote. And then, having been informed by the parties that the proposed application to the Strasbourg court had been made not only by the parents, but also by them on behalf of the child, to remind the Strasbourg court, with all due respect, of the fact that the domestic procedures required that Charlie's participation in the domestic proceedings should at all times have been in the hands of an independent professional guardian. This form of direct communication greatly facilitated the work we then had to do at the Strasbourg court in this, as the Supreme Court rightly pointed out, extremely time-sensitive case. Immensely, and by a decision made on the 27th of June 2017, so well before the deadline we were set, and in fact within little more than a week after the Supreme Court judgment, the Chamber declared the complaint as inadmissible as manifestly found. To me, that is one of the best examples of that multi-layered system at work through dialogue between the judges. And this example also led to a very helpful form of informal dialogue communication afterwards, by which in subsequent end-of-life cases, the domestic courts, frequently the Court of Appeal, would alert the Strasbourg court, frequently through the national judge, that a case of this nature was pending before them, and that if unsuccessful, there was likelihood of subsequent applications to Strasbourg. This early heads up, together with the provision potentially of the High Court judgment at first instance, enabled the Strasbourg court in a number of subsequent applications to be ready and prepared to deal with these applications as swiftly as possible, including in the context of the Rule 39 applications. And I mean, it has to be said, and Robert will no doubt confirm this, the fact that the Chamber managed to deal with an application within a week is virtually unheard of, but it was facilitated by that dialogue. Now, before moving away from the dialogue through judgment, I also want to stress, and I think in the UK this is particularly important, the reach of the dialogue beyond cases against the UK or involving UK law. After all, as Robert and I told the government's Independent Human Rights Act review when we gave, in inverted commas, evidence in May 2011, the sophisticated analysis by the UK courts, we said, of the case law of the ECHR is indeed relied upon in its judgments against other countries. Sometimes the reasoning is discussed by the judicial formation, even if that is not expressly reflected or recorded in the final judgment. Sometimes, however, there's direct and express reliance on judgments of the higher courts of the UK in the judgment itself. And the example we gave at the time was the Danish case of SV&A against Denmark, in which the Grand Chamber changed the Strasbourg case law approach to the concept of kettling, or the detention of football supporters to prevent violence, from adopting a conclusion adopted by the UK Supreme Court, effectively, that the detention was in fact lawful under Article 5.1c, and thereby pivoting away from its own approach under Article 5.1b, as it had adopted in a previous case, Ostendorf against Germany. And again, I just want to point out to a very, very recent example, and that is the recent decision of this happening and the UK court's impact on the wider jurisprudence. And that's last week's judgment in Greenpeace Nordic and others against Norway, the latest installation of the climate change litigation in Strasbourg, where the court considered and referred to the judgments both of the Supreme Court here in Finch and the Court of Session in Edinburgh in Rosebank in identifying the need for an assessment of combustion or Scope 3 emissions to form a part of any adequate, timely and comprehensive environmental impact assessment. So again, one can see immediately how the UK court's jurisprudence is read, understood. The UK was not an intervener, was not a party, and the court cited it and applied it. Now, in addition to the above, there's of course also extensive informal dialogue between the various courts. There are the regular bilateral meetings. I mentioned the meeting in Edinburgh just after I arrived, where between groups of UK judges, usually from all three domestic jurisdictions and the Supreme Court, meet with a delegation of the Strasbourg Court. They happen about every 18 months and alternate between the UK and Strasbourg. And then there are more ad hoc bilateral meetings with the individual domestic jurisdictions or with specialist judges from the UK. And in this context, during my time at the court, it was a real privilege to welcome both a delegation from the Scottish judiciary for an exchange with the Strasbourg judges, and for the first time ever in May this year, a delegation from the Northern Irish judiciary led by the Lady Chief Justice. We also received a visit from a group of family law judges from all three jurisdictions and the Supreme Court led by Lord Stevens. These exchanges are particularly valuable to the Strasbourg Court, and I hope also to the domestic courts, because they highlight to the judges in Strasbourg and enable them to become aware and or form a better understanding of the fact that the UK does in fact have three, sometimes quite fundamentally different and distinct jurisdictions with their own problems and their own issues. So hearing it firsthand from the Lady Chief Justice of Northern Ireland about the security challenge the judges there, and not only the judges, but the judges there are confronted with, or to see the English family law judges being completely surprised to hear of the particular issues that are then already well litigated before the Scottish courts, the trans issue, brought the legal, social and political diversity of the United Kingdom to light in a way that no explanation by the national judge in a deliberation could ever do. Beyond these formal meetings, then also have been, and as I understand it, will continue to be, with Hugh Mercer, my successor, regular, if ad hoc, engagement with the domestic judiciaries in the UK whenever the national judge was here. As in both our cases, our families remain in the United Kingdom. These include regular meetings and exchanges with the respective presidents of the Supreme Court, the Lords and Lady Chief Justices, and some of the other leadership judges in England and Wales, as well as the courts and leadership judges in Edinburgh and Belfast as often as possible. Now, the two other things I think worth mentioning is, and these all come together, which is why I talked about it being quite multifaceted, is on the one hand, there's always a delegation of senior UK judges, frequently including heads of the respective jurisdictions, who come to Strasbourg on the last Friday of January each year to participate in the court's opening of the judicial year, at which again there are informal meetings organised to enable the UK judges to meet not only the national judge, but also the registry team behind the work that happens in UK cases, and to have dialogues with judges of other jurisdictions. So we have always made a point of having a joint table at lunch, and therefore room to debate with the Irish judiciary, who of course also coming on the same occasion. And on the other hand, the national judge and the president of the Strasbourg Court have consistently been invited and have attended the opening of the legal year at Westminster Abbey, as well as the Lord Chancellor's breakfast. And these visits frequently used to enable the president of the court to meet and engage with not only the senior judiciary of the UK, but also the Lord Chancellor and the Attorney General. And then the final forum of dialogue between jurisdictions, less at judges level, but below, is through the Superior Courts Network, in which both the four UK jurisdictions, the Supreme Court, the Court of Session and High Court of Justiciary, the Court of England, Court of Appeal of England and Wales, and the Court of Appeal of Northern Ireland are members, and through which they have privileged access to case law information, including updates on important cases, which is sent on the day of adoption of the judgment, as well as an ad hoc case law information through dedicated focal points. And you may think that's not important, but actually I always thought that was really crucial, because one of the when I was at the bar here, one of the deceptive things was we thought we knew the jurisprudence, but we only knew the half to two-thirds, which is drafted in English. We don't actually know the French, and we can't argue it. But through access to the Superior Court network, the judges will get, on the day of delivery, a summary of the important points of French language judgments, but written in English, so that they can have an awareness about that process. And the inverse is, of course, through the Superior Court network, the domestic judges provide us with the material we need for our comparator. I say us and we, provide the court with the research.
It's still saying we, and I'm
with,
later.
with the research it needs to have as well-founded a comparative law research base for, in individual cases, for the purposes of assessing whether there is a development in the European consensus on a particular question. And it seems to me, and that's, as I said, I mean, there are limits as to what courts can do, but where I started, it seems to me that this rich tapestry of mutual engagement and dialogue has, in my experience, played a, if not the major role in avoiding unnecessary misunderstandings between the national jurisdictions and Strasbourg, and has contributed significantly to the effective protection of human rights in the UK, frequently without the need of the case going to Strasbourg, which is, of course, a reflection of the point Robert made, of the very low number of cases which are there and which are coming to Strasbourg, and amongst those low number of cases that are coming to Strasbourg, the very low number of cases which actually make it past a single territorial committee, because they're obviously inadmissible one way or another. I'll leave it there. Thank you very much.
The mic.
Oh, great.
Sorry. Thank you very much. I'll hold the mic. Thank you very much indeed, Tim. That's some very powerful recent examples of dialogue that I wasn't so aware of myself. So thank you very much for introducing those to us. And I also think of the radiating effect, as I would call it, that can happen, as you mentioned, in relation to cases like Kettling and Article 5, etc., how the dialogue is effective there. I'm left with the impression that the actual machine is working very much in that sense. The machinery, the system is working. It's not broken. It doesn't need fixing. Yet, of course, we face this great fear that the machine will be almost smashed up by political ambitions of certain political parties, if they have the opportunity to do so. So we turn to a Q&A. I thank for the speakers very much for speaking in time as well, thank you, which leaves us the opportunity for a good round of Q&A. There were many strands to what we've just heard, and it's impossible for me to sum them up, but I think of constitutional resilience generally and in the UK particular. I think of the operation of the interaction between Strasbourg and the UK when it's working well and as it should be, as we've heard. But I also think of the broader concern, no doubt, of whether that system will be very significantly disrupted and the issues that could affect that. And it's obvious what I'm alluding to there. So enough of me speaking. Thank you very much indeed for our speakers in agreeing to respond to Q&A to come. I suggest we take 3 sort of questions at once, or comments. Could I ask speakers to introduce themselves when they do so? Could I ask them to be relatively brief in their comment or question? And I would also remind you, I think this session is being broadcast online, so you would need to be aware of that were you to be speaking. Now, do we have a roving mic for this? Do people know? Or you, Linda, there were a couple of hands went up at the back. So let's take 3 questions, comments initially, please. And sorry, one last. If the question's directed to anyone in particular, could you obviously say so? Thank you.
Mark Elliott, and thank you very much to the speakers for Thank you very much to the speakers for those fascinating talks. A question that I think arises out of something that Robert said, but it could be a question for any speaker, is that the point about the UK system very faithfully reproducing the ECHR and allowing direct engagement by British judges with the convention clearly can be regarded as a major strength of the system. I would be interested in reflections on whether in the current political climate it can also be seen as one of its greatest weaknesses, given that it facilitates what I might call the othering of human rights and the portrayal of human rights as a European or external construct, as opposed to something which is mediated through a domestic constitution. Thank you.
Thank you. And just to the right, yes, you're right.
Dimitris Giannulopoulos, City Law School. Thank you so much for your inspirational talks. My question or observation, the combined effect there follows on from a reflection that Judge Spano has offered. Thank you so much for drawing attention to the need for public awareness. Yesterday, the UK government published a review of the national curriculum for schools, and it has placed a renewed emphasis on citizenship. It hasn't mentioned human rights or European human rights for that matter specifically, but there is a renewed emphasis on spending more time and placing more emphasis on citizenship, on the rule of law, on rights more broadly. On the point that you made about how we go about, what type of narrative we promote reasonably aggressively, as you suggested, and I couldn't agree more, the only qualification that I would bring there is, I would draw an analogy with the narrative that we adopted in the UK in the context of the Brexit debate. The narrative was quite aggressive and was quite centered on the fear factor. So what would happen, what the impact would be from withdrawal. It didn't go down very well. So though I completely see where you're coming from, I empathize with that. I would place the emphasis on the positive, as in the stories where we have had a positive effect, both in the UK and also cross-culturally across legal institutions in the way that was described by Judge Eicke, for instance. Thank you so much.
Thank you. And just a couple of, well, please, you, Linda, you know.
Hello, I'm Kustre Mistrefi from Utrecht University. Thanks a lot to each of you for really thought-provoking presentations. I have a comment and a question, but I'll need to explain my thoughts first. So Judge Spano mentioned that we're not talking about a problem of law, otherwise things are quite okay. Also in terms of subsidiarity, we are actually doing quite well. The same with dialogue, yet we're heading towards very difficult times. And Lady Hale mentioned towards the end of your speech whether we should use some populist tactics to advance human rights. And I think this is not something that we talk about, the strategies. What should we do in terms of strategies to actually engage with the populist? In mentioning again history, Ruth Ginsburg used male to advance female rights. Philip Alston has also written how we should engage more and more openly. And we have those TikTok, we have basically many famous people who are active and take the streets, so they are active. But I wonder whether we have failed them in giving tips and tactics, how to strategize, how to advance human rights. So I think people are out there, the youth, looking at, for example, climate change cases. These are all civil society cases. But the strategies they use may not necessarily work. Even if the is good, maybe the cancel culture does not work. What are your tips for those who are out there and would like to promote human rights? What strategies they should use? Should we encourage for more diplomatically, carefully crafted strategies or more head-on collision? I think everyone is looking for people higher up to actually speak up on these matters. Thanks a lot.
Thank you very much. We'll take those as an initial batch of questions. The initial one was initially directed to you, Robert, if I may, but I think the invitation was for others to speak about it if they wish, and then I think the others were mostly also for the panel. So perhaps we can just go,
Sure.
Robert, Tim.
Thank you very much for these questions, which are, of course, extremely difficult, as one could have expected. I'm going to be very interested to hear both Brenda's and Tim's answer to Mark's question, which I think is an important one. The way I conceive of this is we are dealing with largely a perception problem. And I think your question is not a question which relates to what we can term a weakness in the normative context. In other words, if we look at the legal framework we are talking about, which is a human rights framework, and we define and articulate the positive connotations of that dialogue as one which does indeed promote the outcome of that normative system, I would argue that that's a pro rather than a con. The weakness you are referring to is, I think, a weakness which results from misrepresentation. It doesn't refer to the actual operation of the system, but relies on connotations of UK rights being imposed top down from abroad. Now, that is a perception problem. I don't think it's a weakness. It's simply the way you look at the issue, which is in play. Now, having said that, and I think all the questions are similar, how do we address that weakness? And I think, again, it is important that there is realization that the substantive outcomes that we are looking at are actually outcomes that are aligned with UK values and the UK constitutional tradition. So while it may be that they form part of a dialogue between an international court and the UK courts, there is nothing alien about what is happening. We'll talk about migration. We can do that in a moment. But in general, I bet if I would have the opportunity to talk to the British people directly into their rooms, and I would count 150 judgments of the court and ask, do you disagree with that outcome? There are only going to be very few that actually people disagree with. But those disagreements which are in play are magnified by populists. And that comes to Kustrom's question, and we can talk about that.
Thank you very much for this question. This is a very difficult question, and the point that was made by the first question about the faithful transposition possibly being a weakness because it enables this to be labeled as European and othering. I agree with Robert. The othering, the European label, the blue flag with the golden stars, is a convenient label that's been used to frame the debate and the criticism. But actually, the concern I would have, because if you take the other alternative, and we had our own catalogue of fundamental rights, and you got the Strasbourg court saying this is incompatible, it's a violation of fundamental rights, and had to come back to Parliament to be debated, how do we change our catalogue of fundamental rights or our underlying legislation in order to make it compatible with that convention? One would expect the outcry to be even greater. I mean, one of the things I think we've all three highlighted in a way is that because the system functions so well, it addresses the purported concerns of those who criticize the court, namely that it's Europe interfering too much. And then there is the consonance between the values. I agree with the second questioner that actually we have to learn, I think, if you want to engage with this, we have to learn the lessons of Brexit and the fear factor, this is what you're going to lose or this is what's not going to happen. Didn't work then. I mean, I still have that abiding memory. I think the day after a report on the BBC, I think, where a young man was interviewed standing on a newly tarmacked road in Wales in front of a new sports centre,
which had big labels on it saying funded by the Regional Cohesion Fund of the European Union. And when interviewed why he voted Brexit, he said, "What's the European Union ever done for me?" So I do think, and I've in past speeches, I've tried to engage with that to can also show what the convention has given us. There are few cases of findings of violations, but they have been instances where the UK courts, and that's of course the argument that's being made by critics, well, the UK law can protect us anyway, it would do that anyway. But in those cases, it clearly hadn't. And one of the examples I gave was gays in the military. The courts here bent over backwards to kind of make Wednesbury as flexible as it could within the realms of English law, but it wasn't strong enough. And now we have official apologies by the government. We had the Etherton review, all of that. That wouldn't have happened under the common law. That wouldn't have happened without the convention. And you can recite many more examples of this. But how do you communicate that? And there I don't have an answer. I agree with Robert's point, which he made, I think, at the outset, that you know, the three of us, or all of us in this room talking, in a sense, aren't going to move that dial. I mean, I think it's good to think about how we do that. And as I said, I've tried to be a bit more positive about how I kind of say what the convention has done, and where it has stepped in, where the convention, where the domestic law didn't help. I mean, the irony was, in a speech I gave in this room about 2 weeks ago, the point I made, I think the point was made by Naomi earlier, that there was only one judgment against the UK last year, and that, of course, was a judgment in relation to a success fee award and a cost award in defamation proceedings in the domestic proceedings, being a breach of Article 10. The claimant in that case was Associated Newspapers, who of course are the ones who run the headlines as to how we should leave the convention. So, I mean, I can't escape the irony, which is why I take the point about the difficulty of communicating. But I think it's in the framing, and I do think very strongly that actually the faithful transposition is ultimately a strength. And we have to be careful not to allow others to kind of detract from that by othering it. Because actually through the dialogue, which I've tried to talk about, we are actually speaking with one voice in 98% of the time. The odd case where we are not then frequently ends up in judicial dialogue, and we will find a solution, perhaps not in that case, but in others.
Well, I'm not sure how much I've got to add to what's already been said, but of course I'll try. I think, for the reasons that both Robert and Tim have given, it was a very cunning move to incorporate the convention rights in the way that the Human Rights Act did it, and it's had all the benefits that have been mentioned. I myself cannot see any other way of doing it. After all, the attempt to produce a British Bill of Rights was a lamentable failure. And I just dread to think how many people in this room would like to set out to draft a British Bill of Rights with a cat in hell's chance of getting it through Parliament. So frankly, I think we're much better off with what we've got, and we just have to try and point out how it has always represented the values of the common law, and long may it continue so to do. But that's my view. I thoroughly agree with the point that we need to try and communicate the essentials of the British Constitution in schools. We don't do that at the moment. Citizenship education is often about something completely different, and yet we should be doing, and it's not rocket science. And this would include some reference to human rights and what they're there for. But the main features would be what the various organs of government are, what they do, and what they don't do. You know, governments don't make laws, despite the fact they keep on saying we will make a law to do this, that, and the other. And the relationship between them all. I think that's incredibly important. And there is quite a campaign going on at the moment to try and do that. I also would reintroduce the 17th century into the history curriculum. it seems to me to be absolutely staggering that children seem to be taught the Tudors multiple times, World War II multiple times. And the one thing that they are not taught is the foundation of the British Constitution in the 17th century. So we ought to be campaigning for that. I totally agree with you. I also agree with the point that you can't ignore the fear factor. You've got to say, you know, what the deleterious impact internationally and within the United Kingdom would be if we were to withdraw from the convention. We can't not say, you know, what's that going to do in Ireland? I mean, on the island of Ireland. We can't not say that. We can't not say what's it going to do to our reputation worldwide as upholder of international law and international human rights. But what we ought to be doing is emphasizing all the positive stories, all the good things that the convention has done. And there are loads and loads of good stories that come as a result of the convention. I've tried to tell a few of those in a rather understated way in the book I've just published, which is aimed at the general reader and not at lawyers, although unfortunately it seems to be lawyers who are mostly buying it. I won't stop anybody buying it, but the whole idea is to try and get across to the general reader how important the law and the justice system, including the protection of human rights, is to the general reader. So positive stories, I agree. And as far as strategies for the young, I know nothing at all about, I'm afraid, social media, TikTok. I do know what TikTok is, but I don't know anything about it. So all you young people here, think of how you can influence the young people whom you mostly teach, no doubt, to put it out there in the ways that are going to grab the young.
Just one extra, because we're all in such magnificent agreement. Allow me just to, I want to, at least for the matter of debate, a slight pushback on one point. I'm not sure I fully agree with the absolute analogy with Brexit. There are several reasons for that. And this I may say because I'm not a Brit. I don't know that, spend a lot of time here. There is a bit of I think there's both a lot of history that has occurred since Brexit, which I think has created quite a bit of buyer's remorse in this country, number one. Number two is, well, if you look at opinion polls, recent YouGov poll on whether to withdraw from the convention, I don't see that as being the kind of issue which generates the same level of polarity as Brexit did, for various reasons, because Brexit was about economics. It was about, you know, different types of issues that you would see from withdrawal. So I'm not sure I understand the issue, but I'm not sure it's a full analogy there, although we have to be careful. Final point, which is Kustrom's point. I actually believe that a strategy of counter-populism is what is needed. I'll be very honest. Now, coming from a former human rights judge, you may find that shocking. That is because you're perceiving populism as being used as a methodology to achieve outcomes you disagree with, or the kinds of politics you disagree with. But populism used as a way of arousing passions about an issue, that is exactly what we need. With all due respect. So it's a question how you define that. And it has to be a campaign of a reality check. I think it is. And I think what is good for the United Kingdom, it's terrible to say this, but actually what is happening in the US and the way it is viewed from afar on the European continent can go two ways. It can either make us say, whoa, is that where we're going? We don't want that to happen. Or it could be basically like often happens is America starts down a particular road and then Europe follows 10 or 20 years later, which I hope will not be the case.
Thank you very much. I did look up the YouGov survey just then, and it said it was indicating that 46% of the population were opposed to withdrawal, 29% were in favour of withdrawal. So there is a middle ground there. I suppose a reflection I have in relation to that, a middle ground that could sway things. Of course, the dangers arrive when a political party puts it in their manifesto and on withdrawal, and that closes down the discussion, I suppose. But sorry, thank you very much. I've seen at least 4 hands go up, and the first one was Alice Donald, and then, oh, sorry, behind Stuart, behind Alice. Can we take 4 questions, and can you be brief, please? And then hopefully we'll have time for another round afterwards. Stuart, then Alice, if I may. Then there were a couple over here. I'm not being unfair and missing people.
Can you hear me okay? Yeah. Thanks so much for all of the presentations. They're all really interesting. Perhaps I might slightly disagree with Robert about the Brexit analogies. I think the tenor of the debate around this issue has become very scary and very reminiscent of many of the things we saw in the Brexit debate. But I'm really pleased to hear each of you speak about the importance of values in this and this kind of approach to a counter-populist strategy. But I guess my question to you would be, who's actually going to be making the positive case for human rights and for the ECHR within the UK? Because I don't see it happening from the Labour government. I don't see that coming down the pipeline. So I wonder who it is specifically that you would see as making a positive case grounded in the values that we should respect at the ECHR.
Thanks very much. Thanks very much. Actually, on that point that Stuart just raised, I recommend reading the Westminster Hall debate that took place yesterday, now on Hansard, with some very good arguments from Labour and Lib Dem MPs, very relevant to today's discussion. My question was sort of about Canada. So Kemi Badenoch recently, with stunning insight, pointed out that Canada is not in the European Convention on Human Rights. But obviously the point she was making, in which Nigel Farage also quite majored on during his 10-minute rule bill initiative recently, was, you know, forget stepping into the club of 2, Russia and Belarus. What we would actually be doing by withdrawing is stepping into this wonderful sort of, I don't know, transatlantic space or something where we could just be like Canada, you know, they get along just fine, etc. Now, I think all 3 of you have already, at least implicitly, addressed that point, but I would really welcome a kind of direct, you know, what's the best pushback on that argument that the UK could just in a much more benign way be like Canada, Australia, New Zealand, because it seems to me that that's increasingly becoming, you know, one of the sort of bedrocks, obviously completely disingenuously, but one of the sort of bedrocks of the withdrawal case. Thank you.
Thank you, Alice. Professor Alice Donald.
Nori Lidjon, I'm based at the Institute of Advanced Legal Studies, also here at the Charles Clore building. I just want to say quick congratulations to Bickel and University of Leicester for a really excellent event and a really fantastic panel. So this question is for all the panelists. I really welcome anyone's comments or views. A really leading scholar of human rights law, UK and European human rights law, Conor Garrity, passed away earlier this year. And before he did, he published quite a provocative article on what was happening on human rights in the UK. And he was as much, of course, you know, a very established academic as he was an advocate for human rights, especially for its protection. And I just want to put this in the context that we've been here before in terms of populist politicians making the case that we don't need the ECHR, we should have our own Bill of Human Rights. But if I could just introduce an element that critics like Conor Garrity have raised a flag about, is that it's not just coming from populist politicians anymore, that thread. And specifically, he mentioned in his article for the London Review of Books, published in October, that the current UK Supreme Court is quietly editing the Human Rights Act out of existence. And he specifically gave the example of the For Women Scotland judgment in that respect. I mean, just to clarify, he gives many examples, but this is one particular, one very recent judgment. So I think it would be very interesting to hear the views of the panel in that when the dialogue between the national courts is so crucial, as has been highlighted by the panel, and we're seeing this threat come from not just populist politicians with a particular agenda, what can the rest of us do to address this more novel threat?
Do we take one further question, please? Thank you.
Angelika Nussberger. So I thank my colleagues very much for this brilliant talks. And I say from the outset, I hope you give me an optimistic answer. Because what I want to ask you, and Robert told us the history, I mean, the whole thing had the task of stopping fascism, dictatorship coming back. Somehow it also had the task of stopping European people fighting among themselves once again. And it had the task to give orientation in human rights sort of across the countries. The third, the orientation, was wonderfully achieved. The second, stopping wars, was not achieved at all. We know the interim measures, nothing stopped in Georgia, Russia, and in Ukraine, Russia. But the third, about stopping dictatorship and backlash, for me, it's a very, very sad thing to look at the failure of the convention system to stop. And the most striking example is Georgia. My colleagues tell me it's not even authoritarian, it's going into a dictatorship. It's still part of the convention system. Nothing stops them there. We know Azerbaijan, it had been in my section. We had seen all these cases. We have Turkey. So what can we make out of it? I think we have to answer this question to say, well, that was the mission in 1950. This mission is still there, and now it's needed. And if you say, well, look at the United States, it's even good that, well, good in inverted commas, that we can make experience sort of what's happening abroad. But imagine having the convention system and the United States member of the convention. Of course, the court would find violations one after the other. And I think we have to give a good answer to that, also for the debate in the UK, I hear.
Thank you very much. Shall we go through in the same order as last time, if possible, please? Thank you.
I actually want to start with Angelika's question, because I think my answer to that is unfortunately as follows. The convention system is one which does not start in a state or is imposed on a state or is adopted by a state which is starting from scratch on its democratic journey. Remember, the preamble assumes a particular constitutional tradition of the founding states. Why? Because these were all Western European states. I'm afraid the answer to the question in relation to countries like Russia, where we know what happened, Armenia, Azerbaijan, now Georgia. The teaching is that a convention-like structure, which is built on certain prerequisite or premises about social and cultural traditions in the country in question, really have to be in place for a convention-like system to have any chance to survive. Imposing top-down on a system of government which has no democratic origins or democratic ethos will not result necessarily in a successful outcome. It's a sad way of saying it, but I think that is, in other words, let me put it dramatically. Perhaps for Russia, for Azerbaijan, maybe for Georgia, the convention never had a chance. It was unable to embed itself within the generations to come at almost a spiritual level, because that's what needs to happen. That is why the UK is so radically different. because it's already there. It's at the grassroots level. It's already a part of our traditions. And just as regards Canada, isn't the obvious answer with Canada that is a constitutional system with a massively strong Bill of Rights, which has legitimacy within the context of the way the peoples of Canada view the role of the judiciary and the way politicians and the political system has managed that system. It's just a very different constitutional system to the UK system. It may be similar to some extent, as I understand it, correct me if I'm wrong, to the systems down under, where there is a less of a culture, a history of human rights protections like in Australia. But Canada is just not a good example. It does not prove anything. It actually proves, I think, the inverse. That in a system like that, you may, if you've already created a culture of human rights, you may ask a question whether it is needed. Certainly, Canada was not directly affected by the Second World War like the European states, so it didn't have that impetus at that point to be a part of an international system of justice. So I just find that to be a curious example.
Thank you.
Let me also just add a point, partly to Angelica's question. There are a couple of observations. The first is, of course, in many contexts, one can't help but think that the reason the convention is being attacked is because its founding aim was, or one of its founding aims was, to stop a recurrence of fascism, the fascism they'd experienced in Italy and Nazism in Germany. And of course, all the founding fathers, if you read their speeches, from Maxwell 5 over across the French and the Italians and everybody else, make that point very strongly. But it seems to me, so that's one of the reasons I think in order to weaken that early warning system is one of the reasons it's being attacked, which is also why I think many can't actually identify what the problem is they want to address, because I think most of us, the lawyers in the room, if we knew what the problem was, we could engage with it in a way and try and find a legal answer to it. So I think that's one thing. The other thing is the slight irony, which is of course the flip side of that, is that the critics all say we should go back to what the founding fathers meant the system to be doing, which is exactly what it is doing, namely to trying to hold the mirror up to their face and say, well, you can't go, this is beyond what the shared heritage, the shared values permit. And that's why the founding father put in place a system which originally first with the commission only and later with the court was armed to have that external early warning system. The third thing I think is, and like Robert, I don't think I can be optimistic, but what strikes me about it is that history has, I think, also taught us that for most of the member states, if not all of them, the convention and adherence to it has become more transactional and less values-based, which means when you look back to the 50s, when the Netherlands plus the Scandinavian countries took Turkey before the Commission, took the Greek colonels before the Commission to defend the values we shared. If that was still the values-based system which a number of member states were buying into, then we might have a very different result. A, because it would be an interstate case by states who have no skin in the game apart from the shared values which they're seeking to protect. And any execution would be monitored by the very same states who had brought that action. The reason, I think one of the reasons the system fails is because it is dealing with individual applications most frequently. I appreciate that in Georgia, Russia number 2, and of course, Ukraine, Netherlands against Russia, and Ukraine against Russia and Crimea. That is an interstate case, but it is an interstate case which required that state to have been attacked. This is a self-defense more than a values defense. And it's not a criticism, but it's, so I think if we were back, if there were more states who, like the Dutch and the Scandinavian countries in the 50s, were willing to kind of say, well, actually, these values matter, and we will take you to the court because you're no longer adhering to them, we might see a different, outcome. In terms of, and you'll see, I mean, I'm also going to dodge the question about the UK Supreme Court and the threat coming from it. You'll forgive me, but I'm definitely to too close to my last job that I wouldn't want to go there. But I agree with Robert's point about the Canada, Australia, New Zealand argument. One, Canada, of course, has a constitution applying a living tree doctrine, which the Privy Council sitting in London imposed on it. So it does all the things that critics say we shouldn't do, our court shouldn't do, and Strasbourg certainly shouldn't make us do. New Zealand and Australia, of course, have different constitutional models. But I think the debate is always seen, and we see that in the migration debate, the Australian model of dealing with kind of offshoring, to put it neutrally, immigration is frequently taunted as a success. But I mean, those who observed it at the time, and the criticism that was incurred, and of course they are all subject to the ICCPR in one way or another. It's not a court, but it's a supervisory mechanism, was significant. And therefore, actually, that kind of that gloss that, well, we could be like them, misses out a whole lot of factors which actually are hugely relevant to assessing what was the situation in Australia, what is the situation in Australia. And if you, of course, you see some of the parts of Australia who are adopting human rights acts and who are adopting human rights jurisdictions, and therefore, again, in this day and age where shorthand is everything, that's easily said. But actually, as soon as you look at each of those countries, you see that comparison actually doesn't stand up, and it's not a place. It's either, I mean, some of the human rights enthusiasts here may say, well, actually, we want to be Canada. We'd love to be Canada. Because actually that would mean we would have a constitutional court who can strike down offending legislation by reference to a Bill of Rights applying the living tree doctrine. I mean, what's not to love? But I think so. I completely agree. But it flies, and that's the problem. And to the question, who's making the case for human rights? I can see that. Again, I think the likes of the three of us, with all due respect to my two co-panelists, is the fact that we're saying what we're saying is not surprising, but also has very little traction beyond trying to help others to communicate where we can feed in our experiences, our knowledge, etc. But it requires voices who make that positive case, who have the platform. And who also, and I think that's an important part in this whole debate, is at the moment it strikes me that the debate is taking place in a framing that was set by the critics. And actually what it needs is somebody with a platform to reframe the argument. And then let's have an argument about, on the facts, about what the pros and cons of the convention are. And we can all identify cases we disagree with, and you might have decided differently. So I think that's the difficulty, and finding that person is an issue. I just wanted to, as I have the microphone, the point Robert made about populism on this side, and to some extent I take your view, but I think populism is not only associated with making, kind of advocating in a populist way points I disagree with or one disagrees with. But I think nowadays, certainly with social media and everything else, at least as I experience populism, it is by definition built on misinformation or disinformation. And one of the things I think many of us in this room struggle with is, in fact, being able to put the facts out there and put them into the debate, so that the person who's having to engage when it comes to the ballot box, do I vote for a party that has in its manifesto we're going to leave the convention or not? I actually understand what the convention does. I understand what its impact is on the UK. I understand what its potential impact is on me if I happen to be in a situation where suddenly I needed its protection. But it's that problem with the populism label I have, that actually it is built on misinformation and disinformation. And actually the first step into getting this debate onto a level playing field is by getting the information out there and finding a way of getting people to actually understand what the convention does. And of course, they've been really valiant and great attempts at doing that. The Bonavera report was mentioned earlier. There's the report about the impact on the Belfast Good Friday Agreement. Get no coverage at all. And we shout about it, and
But that's the problem. So that's why the populist label strikes me as a bit difficult.
Well, I agree with you because I said at the outset that how I define populism is stirring up people's emotions, often by telling them half-truths or mistruths, rather than telling them the truth. But stirring up people's emotions is not necessarily a bad thing. So possibly we should try and get some emotional power behind our support for the Human Rights Project. This question of who's going to be making the positive case. Again, I agree, I think Tim said this, that it's very unfortunate that the current government seems to be taking the battle on the opponent's terms, as opposed to actually going out there and saying, no, this is a very good thing. The Human Rights Act is a very good thing. The Human Rights Convention is a very good thing. And you are wrong in what you are saying about it for the following reasons. They should be doing that rather than trying to out Farage, which I think will never happen. Well, they're bound to lose. That's the most political thing I could say. But I was encouraged. I don't go to the House of Lords very often because I'm not a parliamentarian and certainly not a politician, but I did go and spend all day there listening to the debate that there was celebrating the 75th anniversary of the European Convention on Human Rights, instigated by Lord Alton. Loads and loads of people spoke. I think getting on for 30 peers spoke. Only 4 of them spoke against. Only 4. 1 non-aligned and 3 conservatives, but there were plenty of conservatives who spoke in favour. It was a very encouraging debate, and everybody said how whatever. I haven't yet read the Westminster Hall debate, but I think that probably is similarly quite encouraging. So there are parliamentarians who are standing up for the convention, and we need to applaud them and encourage them and hope that they will go further. Everything that's been said about Canada. When I mentioned one part of North America doing, I was not referring to Canada. Big fan of Canada, but of course its situation is completely different because it has a written constitution and a Charter of Fundamental Rights, which, though it does have this very interesting possibility of the notwithstanding clause, that Parliament can legislate knowing that it is contrary to the Charter and saying, notwithstanding that, we want to do it. They hardly ever do it, but they can do it, which is quite an interesting safety valve. But as I said earlier, I cannot see that the UK Parliament would come up with a Bill of Rights. Well, they certainly wouldn't entrench it. And I doubt if they could come up with a Bill of Rights, which is better than what we have already. I've been rude enough about the previous thing. Will you forgive me if I don't engage with the question about the UK Supreme Court? I really do have quite strong views about it. And if anybody would like to write down what they think my views are, I expect you'll get it right. But I don't really want to go public on criticising my former colleagues at all. And as for 4 women in Scotland, of course, the ignoring of the human rights element in the judgment is, some think, unfortunate, and it might have altered the result, although who can say that? But what I do feel very strongly about that case is how much it has been misinterpreted and misapplied and thought to decide something that it never did decide. And there is still a big argument to go on about that. But that's an equality argument. It is a human rights argument as well. Again, I'm not qualified really to comment on the problem of the Eastern European and beyond states, but I fully take on board that the original Council of Europe was 12 countries, wasn't it? Western European countries, and possibly Turkey. originally. And obviously, the historic constitutional values in those countries, albeit subverted for a period during the 20th century, were very much in common, and they're declared at the beginning of the convention, very much in common. And I can quite understand why it's overambitious to think that this can be transplanted to countries which have never had those values, or if they have, it's been very much a minority thing. So I agree with everything that Robert was saying about that. But please, can we not be too downhearted? Please, please, please. I was asked, I was doing an event just earlier this week, and I was asked what gave me hope. And apparently Lord Sumption, who was asked the same question, said that very little gave him hope. You know? What gives me hope are all the young people that I meet. I do a lot of university events, some school events, and I meet loads and loads of students, both at school and university, who are mostly bright-eyed and bushy-tailed and full of optimism for the future and fully behind the human rights project. Even those who want to make a lot of money are still full behind it. So what we need to do is energize them and give them the tools to try and energize the rest of the young people in this country. That's what gives me hope.
And we all say here to that question. So I'm afraid time has beaten us, so we won't be able to include a further round of questions, but I hope you will be able to have an opportunity perhaps to speak to people here over lunch, which we'll come to in just a second, or perhaps in a subsequent round of questions later on. I think it just remains for me to say a huge thank you to all our speakers today for bringing their expertise and wisdom in relation to these incredibly challenging issues that are going on, and thank you so much for that, and to Naomi earlier for opening our event as well. I declare this session a great success, although we are fully aware of the great challenges that remain ahead, but I think we're motivated to progress beyond today in the spirit that's been encouraged for us by Lady Hale at the end there. In the meantime, lunch. I feel a bit pathetic saying that. we revert to lunch. Thank you very much. Shall we just thank our speakers in